All right, good afternoon and welcome to this meeting of the Civilian Police Review Board. I'd like to call our meeting to order. Starting first, looking at the minutes from the previous meeting. Hopefully everyone has had an opportunity to review. Does anyone have any edits or additions? Seeing none, I'd entertain a motion to accept the meeting minutes as written. Okay, may I have a second, please?
Second.
All in favor, please raise your hands. All right, thank you. Minutes passed. And turning it over now to the Inspector General for an update from the office.
Good afternoon. You all have in front of you just our monthly summary. So I'm just wanted to highlight a few things. Okay, good afternoon. Okay, you have in front of you the summary of complaints for June, so I'm just going to highlight a few things. For the month of June, we received 110 complaints. And then if you turn it over, just kind of highlighting some things. For the month of June, we've opened 34 investigations. We've completed 19. There are 55 investigations that we have that are active right now. And for the year, the board has reviewed 150 investigations, and right now there are 40 that are under board review. Just noting that we do have a quarterly report that we will be providing to the board. That's going to go from April to the end of June. Obviously, with this being July the 4th, you know, we're still working on getting all of our stats and stuff together. So we should have that quarterly by either August or September, and we'll speak about that. I know that the board is going to be doing a community meeting out for a national out, so I'm not sure. We'll have that discussion whether you want us to do that quarterly review then or just postpone it into September. We can do that. We can still send the quarterly out ahead of time for the board to review, and then if they have any questions. So.
Does anyone have any questions for the Inspector General?
I do. Thank you, Inspector General. Part of the quarterly, I think perhaps this is a conversation for the board, is a opportunity for this presentation to happen at City Council, or there to be some sort of presentation at City Council. I don't know if anybody from City Council's office has been in touch with you all, but I was thinking that might be a good opportunity to do so.
I do know that we did a presentation, and the chair can speak on that. So for the annual report, we did request to do a presentation to City Council, and so we did receive a request from President of City Council Harton to present the annual report to him, and we were able to do that. So I don't know if the chair wants to comment, but what I can say is any of our quarterly and annual reports, once we do those, I make sure that all of that information goes to the board first, and then following the board's review, I do send that out to City Council. But all reports, again, just kind of reiterating, I make sure all that information goes to the board first.
Makes sense. Has anyone, I think something's going on with the mic, has anyone from City Council followed up with specific questions for you regarding the annual report or any updates that they would have?
No, I haven't had any follow-ups. And since we have been in existence and providing those reports to the board, I can tell you that we always, again, once the board gets the reports, we do provide those reports to City Council, the mayor's office, and then we post them on our website for anyone to be able to review if they have any questions. But following your question, no, we haven't received any feedback.
Excellent. And I think it brings up an important point. I think the Department Inspector General, their team have done a tremendous job, have done a lot of work here. We've made those reports available to City Council, the mayor's office. I think maybe as a board, this actually might even be an opportunity to think about engaging City Council on a set of issues, and in particular, if they have any specific questions for follow-up. I know they may not have any specific questions right now, but I do think it might be worth us continuing that engagement, perhaps not just us going to council, but maybe even having some council member representation here, whether it's the elected officials themselves or their representatives. because I think their input is critical for this. Thanks.
Any other questions for the Inspector General? No? I did want to take note and thank the community members who did come out to the town hall last week, and thank you, Dr. Ford, for helping coordinate the town hall at Stonewall Columbus. We did have probably our best turnout of all the town halls that we've had to date, with lots of really good conversation about the work that we've done, but what we still need to do, both as a board and as a broader community, to be able to see more accountability and transparency in policing. So thank you to all the board members who were able to attend. And thank you again to community members who participated and showed up and allowed their voices to be heard. All right, so we did have a couple of cases that we held open from our last meeting, and a couple of cases that were sent to the entire board. Review Committee 1, do you have an update on case number 25-0124?
I do not.
This is a Google Maps case.
Oh, well, we sent that back to the DIG, and did we receive it back in terms of a response that we were asking specifically about the failure? This was a case involving the police showing up at the wrong house because of Google Maps. We found that really troubling, and that they didn't actually check the address. They didn't even check the street. And so we just thought that that was negligent behavior. And so it was sent back, but then what was the response to that? Can you, or maybe Kyle, maybe you know?
I think that was I think Dr. Jones maybe had that direct interaction, but I'm not sure who that might be directed to. The Department Inspector General, if you're familiar with that particular case.
I am, and thank you so much. We got the case back. We did do an investigation. We closed it. We actually closed it yesterday. I believe, is it going to be on the list to be disseminated to the board?
It's still on there. We can send out the updated.
And what was the result of that? Because we thought that there should have been, that the allegation should be sustained as opposed to exonerated or unfounded. So what was your conclusion?
Okay, so based on the allegations, the first allegation involving the interaction that the officer was having, knocking on the door and not announcing himself, we did still exonerate that. But we did add a DIG allegation to that involving two of the officers who were the lead officers responsible for making sure that they verified the address, which they did not, and so we did sustain them for misconduct.
Excellent. Yeah, I think our subcommittee would concur with that.
Yeah.
Yeah.
So we can definitely make sure, if we take a break and the committee wants to review that part and do a finding now, they can. If not, we've closed it, so it'll be listed to go back, so we'll just make sure we send it back to the committee. So, thank you.
Right. And did we make a recommendation? Was there a further recommendation? Because we sent it back, I think we were making a recommendation for a change in policy that officers, if there was a needed change, if officers are regularly checking by way of Google Maps as opposed to verifying by the actual address on a mailbox or on the house and checking the street address, that for us would not be sufficient to knock on someone's door or potentially break the door open.
I think in this case, and I'm just kind of going based on what I was reviewing. So I think in this case, what occurred was the officers used Google Maps to go to look at the location that was next. They wanted to meet up and have a discussion before they arrived. And instead of them putting in the correct address when they responded to the wrong address. But that's what when the officers were interviewed, that's what they were saying. They just used Google Maps to kind of give them a little idea of what the area was for them to meet up and have a discussion. But they still were wrong in the fact that the two officers who were the lead officers that responded should have verified when they arrived at the location, which the address was on the home. They needed to verify that they were at the right address, and they did not.
So I'm not sure that your response is answering my question.
Oh,
So
apologize.
what I'm asking is there a recommendation as part of the DIG's finding that officers not use Google Maps as the only means of verifying an address?
No, we did not make a policy recommendation for that.
I think that was our subcommittee's recommendation, that that's insufficient. In this case, it wasn't tragic. In another case, it could be tragic. There was a case that just was decided by the United States Supreme Court. It involved a federal torts claim. It just came down just a few weeks ago. The FBI broke into the wrong house, smashed things up in the house, and then discovered that, oh, Google Maps, we were not only at the wrong house, we were at the wrong street. And they left, and then they claimed immunity because we're sovereign, there was sovereign immunity. In any case, the court rejected that flat out. The Supreme Court did. This does happen, and it could be tragic. If there's a suggestion, for example, that there were drug traffickers in a house, they then went to the wrong house via Google Maps, announced themselves, you had innocent people sleeping, broke in. It could be really bad. What we're suggesting is, in this case, this is a safe case, we're making a finding that they had violated policy they should have verified, but we want to go a step further. And we want to say that we're going to recommend that Google Maps is insufficient for checking on an address, that they need to verify the address via the house number, the mailbox number. And so that is a recommendation that I'm making to our board right now that we would then follow up with, that would be part of the DIG finding.
So I think we have, correct me if I'm wrong, well, Mr. Tobias is not here, so Ms. Ross, because it was officially sent back to the DIG, don't we have to wait until we get it returned to us to then make the recommendation?
Can we not amend it?
Well, we don't have it back yet. Like because we didn't just ask a question for clarification, we sent the case back to the IG.
There's Mr.
To get the, sure. So here's the question. Last meeting, case number 2025-0124, we returned to the IG for further investigation. It has since been completed, but has not been redistributed back to the board. Like it's going to be this meeting for next meeting. Committee 1 has a recommendation in light of hearing, they asked for what's the new finding. So we know the new finding exists, but we still don't have the report back to us.
The committee's looked at it though already? The updated report? No. Okay.
And verbally said what the new finding from the IG is.
With you so far.
Yep. So procedurally, are we able to do anything just given where the...
Recommendation regardless of the
Today?
status of the report.
Well, I think you could make a recommendation on its own, but it sounds like,
I mean, best practices would be to wait for the report to get back from the DIG to the committee to review it and then present it at the meeting.
That's what I thought, but I'm just making it clear. I'm just trying not to be,
I don't think he's answering the question that you're asking.
he would like to make the additional recommendation now, even though we don't have the report yet.
And when you say recommendation,
It's a policy recommendation, it's not,
Not attached to the case, but a policy
Oh,
recommendation that
you
comes
can
from
do-
the case.
I mean, but it's linked to that, this audio is terrible. It's linked to that case, though. Yeah, you can reference, will the updated report affect the policy recommendation?
no,
Is there any possibility that it would? If there is, I would wait. If it's
no.
literally separate and the new finding or new information will not affect it, you can make it just reference the policy, the case number.
And part of that question, I don't know what's going on with the mics, but part of the question is, what did you all determine was the policy violation? I don't know what the existing policy or lack thereof that they have regarding verifying addresses.
CPD is required. There are certain policies and procedures, so they're required when they're responding to a location to be able to verify that they are in fact at the location. And so we're stating that the officers did not do that, which was a violation of CPD policies.
Maybe it's already taken care of by existing policy. Are you confident that CPD has to check the mailbox or the house number and not go by Google Maps?
Yeah, I can look up specifically, I'll have to look up in the, what their policy specifically says for that. But yes, that is what we're stating. There is a policy that when they respond, they have to verify that they are at the correct location, and they did not do that.
Then, okay, well, I'm making the policy recommendation, but it may already be part of existing CPD policy. I don't know, perhaps then we need to wait to have you check it, what the policy is, but we definitely don't want to be in a situation where police officers are just using Google Maps, as they did in this case.
We will look up that policy and we'll forward that to the committee.
All right, next up, also from our last meeting, Stephanie sent out case number 2025-0084. It was not sent to one specific committee, but it was sent to the entire board. I will review the summary here, and then we can take individual votes on this specific case. So this case on January 31st, 2025, the Columbus Department of the Inspector General received a complaint alleging misconduct by a CPD officer. Specifically, the complainant alleged during a traffic stop initiated by the officer on January 30th of 2025, the officer, quote, wanted me to spread my legs even more while I'm standing there in cuffs as he proceeded to search me thoroughly up under my balls in between my ass, and that's unacceptable. Upon review, the DIG discovered that the allegation, if true, would be criminal on its face. The DIG placed the case on administrative hold on January 31st, 2025, referred the case to CPD Internal Affairs Bureau to review the complaint for criminality. CPD IAB completed their investigation, found no criminality, and returned the case to the DIG on April 11th, 2025 for administrative review. The DIG's investigation consisted of a review of CAD data, a review of BWC footage, a review of the IAB investigative report, and a review of applicable CPD policies and procedures. In regards to the allegation, the investigation revealed the officer conducted a pat-down that would fall within the scope of the officer's official duties. At no point does the focus officer conduct a pat-down that would substantiate the complainant's allegation of impropriety. At no point during the pat-down conducted by the focus officer is there an allegation of inappropriate contact in the genital area. The officer's action in this incident aligned with procedure and CPD policy. The DIG concurs with the IAB's finding, therefore recommends that the case be closed as an administrative closure. Does anyone have any questions either for the IG or other points of discussion related to case number 2025-0084?
I have a question on this case regarding, let's see, it's a question for Mr. Tobias. It does not have anything to do with the search. Well, it's an ancillary search. The focus officer in here, I believe, went into the compartment in the automobile. And this was it was a traffic stop, an officer-initiated traffic stop, where they took the individual out of the vehicle, I believe. And when I read it, I couldn't figure out what the reason was for the officers to search the automobile. There was marijuana odor, and they even if they were smoking the marijuana, what would the reason have been?
I haven't seen the report. I don't know, maybe there was consent by the
I
driver
didn't-
or the passenger,
I didn't see consent.
or some other reasonable articulable suspicion, but I have not seen, I've not reviewed or read the report, so I don't want to speculate.
And I'm not sure if we can do this, but he was training another officer in this particular situation here. So, and that was the reason why they double searched this particular individual. And I'm thinking that if this focus officer is training someone and he is he does not know the search and seizure laws, that even though this wasn't, and I'm not sure if we can do this, that's why I need your help here, that he should maybe be instructed to take lessons in the search and seizure law, because he cannot be training individuals on the search and seizure laws if he is going to be searching automobile compartments without, unconstitutionally, illegally. So this is what bothered me in this case.
That could be something you could send back to the DIG for follow-up, just determine if there's more information that can be gathered, and if not, I can certainly look at the report and
I think
see if I
that-
get some more information.
I would like that if,
So what it looks like here for Mr. Tobias, just for your benefit, the only justification for doing a search was that the marijuana was alleged to have smelled burnt. So instead of just simply possession, which is not against the law, the allegation was that he was smoking while driving. And so that was the cause. And it looks like it was the trainee who did the compartment search after the pat-down happened.
I mean, with the officer's question by the DIG in relation to the search?
No, I don't believe so.
I mean, you could send it back for follow-up to inquire, but, yeah. I mean, if you're asking, we want to make some recommendation for there to be some additional training, follow-up training, education. Obviously, your decision as to whether to recommend that or not would be based on a full set of information and facts as to why they searched the compartment in the first place.
I think it's important because this is a trainee, and if he thinks that, if he isn't trained enough to know that he can't go into compartments, or if the officer who's training him doesn't know that he can't go into compartments constitutionally, I would be concerned, and I would like for him to read the law.
Well, I haven't seen a U-10-100 police report. I don't know what's in there.
Yeah, and neither.
For all
and
I
we
know,
don't
there was
either.
consent.
That's true.
I just
That's
don't know the
true.
answer to that.
So maybe we could do have a little bit more background on this particular case.
That would be my.
But it would be problematic if there was no consent.
Yeah, it would be.
May I ask a question? Was the complaint for the body search, or was the complaint for the search of the car?
Okay, that's what I said at the beginning.
Yeah.
That wasn't the issue.
Right.
However,
Agreed. So what I would say is so when you send it back,
yeah,
if the DIG determines that there is a violation of search and seizure pursuant to the way the car was searched, the DIG can then issue her own, allegation, or the board can issue its own allegation. I just want to make sure we
Yes.
separate it, make
Yes.
it separate and apart from the
Yeah.
the
Yeah.
citizen complaint.
yeah, I realized that wasn't the issue here. It's just that the search was, I thought, a little bothered me. It was a little egregious.
So it sounds like we want a motion, or at least want a motion to collectively say we want to return it back, not move forward with the report as written. specifically to see if the IG will investigate whether there was an issue with the search itself. So did the search itself of the car violate CPD policy or procedure?
I have a few more questions.
Uh-huh.
I think so. So there's that piece regarding the search itself, and then also just a question in terms of process. So this was done through an administrative review because it potentially had elements of criminality here if there was a sustained finding, and so IAB looked at this case. Then there's administrative review from Department Inspector General. In this case, if I'm reading it correctly, the complainant was not interviewed in this instance. Was just wondering why that was the case here, and then if that's standard practice for these administrative reviews. And then two, as relates to the pat down itself, in this particular case, it also indicates that it wasn't even clear whether or not the trainee was assigned to that main officer. It actually potentially was assigned to somebody else. And so I do think there are some remaining questions that I have about both the search of the car in the first place, but then also the pat down itself, that in terms of just that process.
Send the report back with all of your questions, and we'll definitely look into it.
Can I officially get a motion, though? Just so that we have clean minutes to return it.
Let's see. We would move at this time to have case number 2025.0084 returned to the Inspector General for investigation as to the search and seizure issue as to the compartments in the automobile and the search of the individual and any other, and I can't remember the third one, Kyle.
I think that's
Is that enough? Okay.
If Stephanie has notes. Okay, may I have a second, please? Second. All right, all in favor, raise your hands. Perfect. All right, and the last one from a holdover from last time was case number 2025-0140. That one, I believe, combined committees 2 and 3 had a question for Mr. Hurler.
Yeah.
Okay.
That was just continued, so I'll go ahead and review that. This was a case where the IG received a complaint regarding CPD. The officers, the allegation was such that the officers assaulted the complainant by stomping on her feet, placing the handcuffs on too tight, throwing her up against the police vehicle, and strapping her to a bed tightly to transport her to jail. The investigation consisted of interview of complainant, interview of focus and witness officers, review of CAD, review of use of force report, review of police report, BWC, and footage, and CPD policies. The investigation did find that while an officer did step on complainant's feet to prevent her from kicking, there was no evidence to substantiate the complainant's allegation that CPD officers assaulted her by stomping on her feet. The complainant mentioned her handcuffs were too tight, and the officers immediately adjusted them. Additionally, CPD officers were never observed throwing the complainant up against a police vehicle or any vehicle. Lastly, the complainant was restrained to a stretcher. However, due to her continued resistant behavior, officers elected to hobble, strap, and restrain her to the stretcher in order to gain and maintain control of her. Therefore, the DIG recommends a finding of unfounded. My committee continued this last week because we thought we should view the footage in this particular case. And Crystal Jackson did go and view the BWC footage. And so we actually discussed, our committee reviewed this case twice. So we reviewed it again, and she found, and after discussing it, the footage, the BWC did show that it was necessary to use the level force to restrain her, to actually protect her and the officers, because she was being very non-compliant, and it was necessary to secure her, make sure she didn't hurt herself or the officers, and secure the arrest in a very safe manner. So we did, after all this discussion and viewing, agree with the Inspector General's findings. The next, that's it,
So you can
sorry.
make- You can make a recommendation
Yeah.
and motion on that.
So we move to accept the findings of the Inspector General on this case.
Okay, I have a second, please. All right, any questions? All right, all in favor of moving, please raise your hands. Any abstentions? Board Member Strickland. Noted, thank you. All right, turning it back to Board Member Nathan for Committee One's reports of June cases.
Okay, thank you. This is case 2025-0072. The incident arose as a result of a call reporting a person with a gun at the complainant's home. The complainant alleged that, let's see, as a result of CPD misconduct, his fiance's money was stolen, that officers searched the home illegally by going through drawers and boxes, and that he was removed from his home without being advised of a reason. In regard to allegation one, the investigation found no evidence that the complainant's fiance had any money stolen, so it was recommended that allegation be closed with a finding of unfounded. Regarding allegation two, the investigation found the officers were on a call for service involving a person with a gun. They did a sweep of the home, but there's no evidence that they performed an illegal search by going through drawers and boxes. And with respect to allegation three, the investigation found the officers did remove the complainant from his home without being advised of a reason, but once he was away from the scene, they advised him of the complainant of the circumstances, and they're authorized to remove the individual from a scene expeditiously and detain them. So the officers, so this allegation was closed with a finding of exonerated. We agreed with the DIG's findings with respect to allegation one of unfounded, allegation two of unfounded, and allegation three of exonerated. Case 2025-0085. This incident arose as a result of a homicide in the area where the complainant's teenage son and daughter were. The officers were looking for a suspect with light skin and dreads. The complainant alleged that the officers wrongly detained her teenage children. Second, that they used force against her daughter. And third, that they made an inappropriate physical contact around her daughter's private area during a pat-down. With respect to the first allegation, DIG found that the investigative detention was within CPD policy. They were locating a wanted homicide suspect, and so they closed that with a finding of unfounded. Second, that the brief detention of the complainant's children, that there was no, the investigation did not find that the officers used force during the incident in violation of CPD policy, so they closed that with a finding of unfounded. And third, that the pat-down of the complainant's daughter was appropriate and it was not a inappropriate pat-down of a private area, so they closed that with a finding of unfounded. And so we agreed with DIG's findings in all cases that these were unfounded. Case 2025-0107, this incident arose as a result of the complainant's juvenile son being arrested as a suspect in an attempted car break-in. The complainant alleged that their son, the complainant alleged officer misconduct in suggesting that the officer advised the Juvenile Detention Reception Center that he had contacted her about her son being detained by CPD, but in fact did not contact her. The investigation found that the officer did not, in fact, advise the Juvenile Detention Reception Center that he had contacted her, and so there was no evidence to substantiate the complainant's allegation. Therefore, it was recommended the allegation be closed as unfounded. Our subcommittee concurred. It was case 2025-0107, 2025-0160. The complainant was stopped for allegedly driving with her high beams on. The complainant alleged two things. One, that the officer threatened to issue her a citation if she argued with him, and second, that the officer was aggressive in not allowing her to demonstrate the difference between her high and low beams. The DIG added a allegation of misconduct in that the officer was discourteous in his interaction. Regarding the first allegation that the officer threatened to issue her a citation, the first officer did not threaten her, but a second officer came along and did threaten her and said, "Do you want a ticket?" The complainant interpreted the officer's statement as implying that her continued request to demonstrate her vehicle lights would result in a citation at which a reasonable person in the DIG's assessment would have perceived as a threat. And so the DIG found that CPD policy was violated in that the officer was not acting in a civil, orderly, or courteous manner. So with respect to allegation one, DIG closed that with a finding of sustained. Regarding allegation two, that the investigation found the officer advised the complainant that her high beams, having her high beams on, could result in the issuance of a citation. But there was no evidence to support the complainant's allegation that his behavior was aggressive, so DIG closed that allegation with a finding of unfounded. And third, DIG, as I said before, added a allegation, and that is that the officer was discourteous by walking away in the middle of an attempt by the complainant to demonstrate the difference between her high and low beams. And there was actually no evidence that her high beams were even on as an initial matter. So they sustained that additional charge. We concurred with the DIG's findings of sustained with respect to allegation one, unfounded with respect to allegation two, and the additional claim of sustained with respect to DIG's additional allegation. Case 2025-0171. This incident arose as a result of a traffic stop for alleged failure to signal and window tint violations. The complainant alleged three things. First of all, that the officer stopped him for window tint and immediately asked him to step out of the vehicle, which he believed was inappropriate. Second, that they attempted to bust his windows. And third, that the officers beat him after removing him from the vehicle. With respect to allegation one, in this case, the complainant had his driver's door window only lowered part way. The officer directed the complainant multiple times to lower all the windows so that the officer could see into the car. The complainant did not comply, so the officer ordered the complainant out of the vehicle. They're authorized to order a driver from the vehicle during a traffic stop. This allegation was closed with a finding of exonerated. Regarding the second allegation that the officer threatened to bust his windows, in this case, the DIG found that the officer ordered the complainant to exit the vehicle. The complainant refused to comply. He was advised he was under arrest, and when he again ordered the complainant from the vehicle, and instead the complainant rolled up the driver's door window. The officer attempted to open the door, found it locked, and stated to the other officer, "Bust his windows." There's no evidence of a physical attempt to actually break the windows by any other officer present, and so they closed this with a finding of unfounded. And third, that when the complainant exited the vehicle, the officer struggled to gain control of the complainant's arm for handcuffing. Another officer assisted him. The actions taken to gain control of the complainant once he was restrained are supported by CPD policy. And so DIG said that there was no evidence that the complainant was punched, kicked, struck, or in any way beaten as alleged, and they closed that third allegation with a finding of unfounded. So with respect to allegation 1, the DIG closed it with a finding of exonerated. With respect to allegation 2, they closed that with a finding of unfounded, and with respect to allegation 3, they closed it with another finding of unfounded. We concurred with all of the DIG's conclusions. Case number 2025-0194, the complainant alleged that the officer tried to provoke an altercation with her. The complainant had a child with the officer's late son. In this case, the complainant withdrew her complaint, and the DIG dropped the case. They found that there simply wasn't enough evidence to move forward with this particular case, and after reading the DIG's findings, we concurred with their findings. Case 2025-0214. This incident arose as a result of another traffic stop for failure to signal. Complainant alleged 2 things: that the officer removed him from his vehicle for a traffic stop, which he believed was inappropriate. They arrested him without advising why he was under arrest, and that the officer searched his vehicle without his permission. With respect to allegation 1, the officer ordered the complainant out of the vehicle several times and advised the complainant that he would be arrested if he continued to refuse to exit. He also told the complainant what offense the arrest would be for, and then effected the arrest. The officer's actions were in accordance with CPD policy, and so DIG concluded that the allegation 1 be closed with a finding of unfounded. With respect to allegation 2, the investigation revealed the officer did in fact arrest the complainant and advised him of the reason for the arrest. That also was in accordance with CPD policy, and so DIG closed that with a finding of unfounded. And finally, the investigation revealed that one of the officers did conduct a vehicle search. However, the search was a vehicle inventory because they were impounding the car. This was in alignment with CPD policy, and so allegation 3 was closed with a finding of exonerated, and so we concurred with the 3 findings of DIG in case 2025-0214. Case 2025-0262, this incident arose as a result, again, a traffic stop and for failure to signal. In this case, the complainant alleged the officer pulled the complainant and his father out of the vehicle. The officer slapped the complainant's phone out of his hand. Number 3, that the officer used profanity, saying, "I don't effing gotta get a sergeant." Allegation 4, that the officer damaged the complainant's vehicle, specifically damaged the center console by indicating the lid had been ripped off, and that the passenger side door was scratched by a drug dog that they used to check the vehicle. Regarding allegation 1, both the complainant and his father were ordered out of the vehicle. Neither officer pulled the complainant or his father from the vehicle, according to body-worn camera evidence. Both were assisted from the vehicle using authorized escorting techniques. So allegation 1 was closed with a finding of exonerated. Regarding allegation 2, that the officer slapped the complainant's phone out of his hand, the complainant failed to comply with the officer's demand that he put his phone down. The officer took the complainant by the wrist to assist him from the vehicle. The phone tumbled from the complainant's hand during the interaction, but the officer didn't slap his phone or slap at the phone or have any other interaction with the complainant's phone. So it was recommended that allegation be closed with a finding of unfounded. Concerning the statement that he's that he used profanity, the DIG found that the officer did not use profanity. He simply said the sergeant's not going to come out, and so that allegation was closed with a finding of unfounded. Regarding allegation 4, that they damaged the complainant's vehicle beyond any pre-existing condition, they also closed that with a finding of unfounded. There was no evidence to support that. And finally, the narcotics dog are trained with an active response to a scent to include scratching. So apparently dogs can scratch your car during a drug search, and it was recommended that that be closed with a finding of exonerated. So we learned something about drug dogs. So we concurred with the findings in the DIG's findings on those 5 allegations in case 2025-0262. Case 2025-0267, this incident arose from a fight that the complainant had with a neighbor. The complainant alleged that the officer did not fully investigate the claim of assault by the complainant's neighbor. The officer attempted to identify the alleged assailant, but was initially unable to identify them. But after further investigation, he was able to identify the alleged assailant. And so the conclusion by the DIG was that although charges were not initially filed at the time of the incident, due to the officer indicating a lack of probable cause, after further investigation, charges were filed, and the responding officer's actions were supported by CPD policy. So the DIG closed this with an allegation, with a conclusion of unfounded. We concurred. Just 2 more. 2025-0270, this incident arose as a result of a domestic violence complaint between the complainant and his child's mother. The complainant alleged the officer did not complete the police report accurately, specifically the portion of the report that states victim 1 was unable to say how he obtained those scratches if suspect number 1 attempted to cause harm. The investigation found that the officers, in this case, when the officers arose, the other individual was not present on the scene as they had already left. They were unavailable to provide their account of what occurred. The officer completed the police report accurately using the information that was available, and so it was within CPD policy, and they closed this case with a finding of unfounded. We concurred with that. Last case, 2025-0277. This was a domestic violence incident. The complainant alleged that the responding officer failed to arrest her niece's significant other for domestic violence. The complaint initially was emailed to the CPD's, the Columbus Police Department's chief's office. They then contacted the zone sergeant. An investigation was transferred by IAB to the DIG, and so here were the conclusions. First of all, the complainant alleged that the officers failed to arrest her niece's significant other, even though she believed there to be sufficient evidence. Preliminary investigation showed there was enough probable cause to file charges for domestic violence, and so the failure to file charges of domestic violence was not within CPD policy. That complaint was closed with a finding of sustained. Second, that the officers failed to properly verify a warrant before making an arrest upon the suspect. In this case, one of the focus officers admitted to the violation of the formal statement in the warrant, and so the DIG closed that with a finding of sustain. Third, that the officers executed a warrantless entry into the suspect's residence without proper requirement to do so. This violation was observed by the zone sergeant, and so the officer's action was not within CPD policy. Those last two allegations were added by DIG. The first one was brought by the complainant. In each case, the DIG concluded that the allegations were sustained. We concurred. And so I want to move in all of these cases. Do I need to recite them again? I mean, the numbers?
You're fine, I'll recite them
All.
when we call the motion.
Okay. So we're moving to accept the DIG's findings in all of these cases.
Okay. So we've got motions in 25-0072, 25-0085, 25-0107, 25-0160, plus an additional allegation from the IG in 25-0160, 25-0171, 25-0194, 25-0214, 25-0262, 25-0267, 25-0270, 25-0277, plus two additional allegations in case number 25-0277. May I have a second, please? Second. Okay. We have a second. Do we have any questions for the review committee on any of those cases?
You did good.
All right, seeing none, I'd call the motion. All in favor, please raise your hands. Any opposed? Any abstentions? Motions carry. Thank you, Board Member Nathan. Now turning over to combined committees 2 and 3.
Case number 2025-0146. The complainant filed a complaint alleging misconduct by CPD officers. The complaint stemmed from the officers attempting to make a high-risk traffic stop after a vehicle fled from CPD officers. The complainant alleged the officers approached her vehicle with their firearms drawn. The investigation consisted of an interview with the complainant, interview of 2 focus officers, review of CVS footage, review of BWC footage, review of CAD materials, and CPD policies. The investigation found the officers were initially attempting to stop a vehicle where the owner had felony warrants, and the vehicle fled from CPD officers after they attempted to make a traffic stop. The involved CPD officers discovered the complainant's vehicle, which matched the description of the vehicle that had just evaded them within a 5/10 mile area that was proximity where they attempted their initial stop. The officers stopped the complainant's vehicle with their firearms drawn and treated the stop as a high-risk traffic stop. The officers had reasonable suspicion to stop and approach the complainant's vehicle in that specific manner. The officers promptly concluded the stop upon determining that the complainant's vehicle was not the one they had originally intended to stop. Therefore, the DIG recommends that this allegation 1 be closed with the finding of exonerated, as the officer's actions did not violate CPD policy and procedure. Our review committee reviewed, and we do concur with the findings of the Inspector General. The next case was case number 2025-0164, and upon review of this case, I did contact Stephanie, and this case is a duplicate. We already reviewed this at a prior hearing, so I'm not going, and we've also voted on it. So the next case is case number 2025 let's see.
0167.
Well, give me just 1 minute. 64. I might need yours. Oh, thanks. What did I do with it? All right. 2025-0167. This is an allegation of misconduct by CPD officer. The complainant said that on February 26, 2025, he was involved in a motor vehicle accident, and the at-fault party left the scene. The complainant alleged, 1, the officer did not give the at-fault driver a citation for leaving the scene when he found her, and 2, the officer did not provide him with the at-fault party's information, including her name and insurance information, and 3, the officer called him a liar during his phone interaction with the officer after the accident occurred. The investigation consisted of interview with the complainant, review of CAD report, review of BWC, review of ECC information, and a review of CPD policies. Pertaining to allegations 1, 2, and 3, on March 27, 2025, the complainant advised the DIG that he was no longer pursuing his complaint and asked for the complaint against the CBD officer to be withdrawn. Therefore, the DIG recommends that allegations 1, 2, and 3 be closed as withdrawn. So we did review this, and we agree with the finding of withdrawn by the Department of the Inspector General. The next case is, thank you, case number 2025-0193, and this was a complaint filed with the Inspector General. The allegations are, number 1, Columbus officers were aggressive when they arrived and didn't handle the mental health crisis appropriately. Number 2, the complainant's father sustained a T-12 fracture and bruising caused by the officers during the incident. 3, CPD officers injected the complainant's father under the tongue, and CPD officer hit the complainant's father in the chest with a flashlight while in the back of the ambulance. And 5, CPD officers were not wearing BWC the entire time. The investigation consisted of interview with complainant, the complainant's father, the complainant's husband, interview with the focus officers, CAD data, all of the BWC footage, review of video footage submitted by the complainant, review of documents submitted by the complainant, and review of policies. The investigation, after review of all the evidence, found no evidence to substantiate any of the allegations made by the complainant or her father. The BWC footage and the officer statements contradict the complainant's total version of the events. The CPD officers followed policy and procedure when dealing with suicide attempts and mental health crises. No officers were observed being rude, aggressive, impolite, or disrespectful toward any individual during the entirety of the incident. The complainant failed to provide any evidence to support that her father sustained a T-12 fracture or bruising as a result of the incident. At no time during the review of the BWC footage was the complainant's father administered an injection by CPD officers or paramedics. Once the complainant's father was placed in the ambulance, no officer touched him, and no other incidents occurred. All 4 officers BWC were active throughout the entire event. Therefore, the DIG recommends that this finding be unfounded for all 5 allegations. We did review the entire case, discussed it, and this was a very thorough investigation by the Inspector General, and we, as were the other ones, of course, and we do concur with the finding of the Inspector General. The next one, we reviewed case number 2025-0209. The next one is it's also an allegation of misconduct. This one was, an allegation that a CPD officer was rude when speaking with a Walmart employee. 2, was rude by using profanity towards the complainant. 3, smacked the top of the complainant's daughter's car seat. 4, threatened the complainant by saying he was going to have her child taken by Child Protective Services. And 5, swatted the complainant's phone in her hand when she was attempting to take a photo of his badge. The investigation consisted of interview of focus officer, review of CAD data, review of Walmart video footage, and a review of CPD policy and procedure. There was no body-worn camera available for the incident, as the officers were on special duty, and this occurred on March 17th, 2025. Actually, it occurred prior to the time that that there was that they had to wear that they could wear BWC. The investigation found no evidence to substantiate any of the complainant's allegations. The investigation found evidence that directly refuted the allegations made by the complainant. Therefore, it is recommended that all 5 allegations be closed as unfounded. Our committee did review, let me look at this one. Sir. Okay, our committee did review all of the allegations, and we did concur with the findings of the Inspector General. The next one is 2025-0243. This was an allegation of misconduct. The complaint stemmed from a telephone conversation between a civilian human resources professional within the Department of Public Safety and a sergeant within the CPD. The complainant alleged that the focus officer used profanity towards her while she attempted to assist him with a human resources related issue during a phone call. The DIG's investigation consisted of telephone contact with the complainant and a request for records of the alleged telephone call between the complainant and the CPD sergeant. The investigation found that there was no recorded phone call that existed between the complainant and this CPD sergeant. Additionally, the complainant requested to not have the complaint moved into a formal investigation. Therefore, based on the aforementioned information, the Columbus DIG recommends that this allegation be closed with a finding of withdrawn. We reviewed this, and we do agree with the finding of the Inspector General. Case number 2025-0273. This was forwarded from IAB. It was a citizen complaint from CPD Internal Affairs alleging misconduct by a CPD officer. The complainant alleged, 1, on March 31st, 2025, a CPD officer working guard duty at Grant Medical Center was sleeping while on duty. The DIG's investigation consisted of an interview with the complainant, interview with the focus officer, review of CPD IAB, a photo of the focus officer on guard duty received from Grant Medical Center Protective Services, a review of information from ECC, and a review of applicable directives. Pertaining to this allegation, the officer told the DIG that he did not remember being asleep. He had not taken any medication, had no physical impairments, and there were no factors that affected him while he worked guard duty. He further stated he was tired, and he closed his eyes for a minute or two. The investigation found evidence that substantiated the complainant's allegation, and the alleged incident did violate CPD policies and procedures. Therefore, it is recommended that this allegation be closed as sustained. Our committee did review this case, and this allegation should be sustained, and we do agree with the Inspector General that that this should be a sustained allegation. Next, I have, the next one is 2025-0278. This is an allegation of misconduct. The complainant alleged that on April 4th, 2025, between 12 and 1 p.m., he and his sister were traveling in their vehicle on Fifth Avenue when an officer who drove police vehicle unit 51 drove past her vehicle to avoid traffic and turned left on a side street. The complainant alleged that the officer nearly sideswiped his sister's vehicle to avoid traffic. The DIG's investigation consisted of an interview with the complainant, a review of CPD IAB Global Position GPS report for Unit 51, a review of information from the ECC, and a review of CPD policy and procedure. Pertaining to this allegation, the complainant alleged the officer driving the police vehicle 51 nearly sideswiped his sister's vehicle in which he and his sister were traveling. The investigation found no evidence to substantiate the complainant's allegation. Unit 51 was, first of all, not in the area where the alleged incident could have occurred at the time it was alleged to have occurred. Follow-up with the complainant and his sister was unsuccessful to determine if it may have been a different vehicle. Therefore, it is recommended that this allegation be closed as unfounded. Our subcommittee reviewed it, and we do concur with the finding of the Inspector General. Next case, 2025-0298. This was an allegation of misconduct. The complaint stemmed from the arrest of the complainant for a forgery charge. The complainant alleged police misconduct arose during his arrest due to his race, ethnicity, and religion. The investigation consisted of a review of an email sent by the complainant, interview attempts by the complainant, a review of CAD from the incident, review of BWC footage, the review of the U-10 from the incident, and a review of applicable CPD division directives. The complainant failed to cooperate with the DIG's investigation and never provided a formal statement. Additionally, the investigation found no evidence to substantiate the complainant's allegation. The officers were dispatched to a call for service and found probable cause to arrest the complainant. The officers' actions were within policy and procedure. Therefore, the DIG recommends that this allegation be closed as unfounded. We did review this case, and we do concur with the findings of the Inspector General. The next case is 2025-0308. This was an allegation of misconduct. The female complainant alleged, 1, the officer was rude by throwing her driver's license on her lap and yelling at her. The male complainant alleged, 2, the officer aggressively grabbed at him. The investigation consisted of interviews with complainants, review of CAD data, review of BWC, and review of policy and procedure. With regard to allegation 1, the investigation found no evidence to substantiate the allegation that the officer was rude and threw the license at her. And so it is recommended that this allegation be closed as unfounded. And as to number 2, the aggression as to the male, there was no evidence on the BWC that this occurred, and it is recommended that this be closed as unfounded. We did review, our subcommittee did review this, and we do concur with the Inspector General. And the last case is 2025-0373. This was misconduct via the hotline. The complainant alleged, 1, the officers did not take a report to document the abuse. The complainant reported on May 3rd, 2025. Number 2, the officers took a report that named the complainant's husband as the victim, even though the complainant was the one who called. And number 3, the officers provided the complainant's husband a report, but did not provide her a report number for the incident that took place on May the 3rd. The DIG's investigation consisted of an interview with the complainant, a review of CAD chronology, a review of CVS footage, review of BWC footage, and a review of policy. With regard to allegation number 1, the investigation, the investigation found that while the officers were initially dispatched on a call for service regarding a DV incident, there was no evidence of a DV. Thus, the incident became a domestic violence dispute rather than a domestic violence call. Domestic violence dispute incidents do not require a report. Therefore, it is recommended that this allegation be closed with a finding of unfounded. As to number 2, the investigation found no evidence to substantiate this allegation. No report was taken for this incident, nor was a report required to be taken. Therefore, it is recommended that this be closed as unfounded. With regard to allegation number 3, the investigation found the incident number provided by the complainant, which she claimed to be from an incident on May the 3rd, was actually from a previous incident in March of 2025, not May the 3rd. No report was filed for that incident, and nor was a report required to be taken. Therefore, it is recommended that this allegation be closed as unfounded. Our subcommittee did review this, and we do concur with the findings of the Inspector General. As to all these cases, our committee moves that the findings of the Inspector General be accepted.
Okay, we've got motions now on case number 25-0146, 25-0167, 25-0193, 25-0209, 25-0243, 25-0273, 25-0278, 25-0298, 25-0308, and 25-0373. May I have a second? Second. Okay, any questions for the committee on any of these cases? Okay, seeing none, I'll call the vote. All in favor, please raise your hands. Any opposed? Any abstentions? None taken. Thank you, subcommittees 2 and 3. We can go straight into kind of our policy discussion points. At our town hall last week, a number of issues regarding officer training came up around a myriad of issues, including mental health training, CIT, cultural competence, marginalized communities. So my thought was, if we could, and if you all agree with this, invite someone from the training academy to come give us kind of an overview of updated modules on the topics that were brought up at the town hall. There's about 4 of them, I think. And it's been a while since we've heard anything from the training academy. But I figured that might help us in the event that we are trying to make recommendations on specific to the training needs of officers based on the needs that came up at that town hall. So how would the rest of the board feel about having? Okay. Okay, Stephanie, would you mind reaching out to the training academy and seeing if we can get, whether it's the commander or faculty, but if we send over kind of a, here's what we'd like to see, and then we give them the topics that came up, that would be great. And see when they can make it. Since we already have Commander Lip coming in September, if October, November, December, if one of those is available, that would be great. Okay. Also, an issue that came up, one of the attendees at the town hall brought up the issue of officer wellness. And so, because that's not specific to training, I figured that might also be a helpful thing to hear about. We had a visit from the dogs who came, which were great. But I do remember there was a training a while back that we had early on when we were formed that talked about what wellness avenues were available to officers. My recollection is that those were voluntary only, so they're not required. And so wondering if the board would be interested in hearing an update on that as well, given some of the concerns that we heard from attendees. Is that something folks would be interested in?
That'd be good.
Okay. Could we check on that too? I think it's a different department than the academy, but
I want to say it was Adam H. or something, because they came here and did something with you guys. It's when you all had a presentation on the mental response unit, or the, yeah, mental,
actual units that.
yes. Yes, and they were talking about it during that presentation.
Okay.
So,
So maybe we can get them at some point after the training academy commander. That would be great. Okay, now I'll open the floor. Are there other topics that folks would like to bring to the floor? I do also want to acknowledge and thank everyone for sending questions for our September meeting for Commander Lip. I think we have about 10.
Points. Number one, was my question added, Stephanie, to that? I sent a question about a month ago.
any questions I got, I literally just was copy and pasting you. Forward. I have a draft of the memo. I know Brooke was looking at it, but every single one of your questions, even the ones that you guys had the last meeting that I said send to me and they weren't sent, are added to the memo.
Okay.
But I can go ahead and yeah. Brooke, would you? Do you want?
Yeah, if you want to send
The
the draft
draft.
to the whole
Okay.
board, that's fine.
That'd be great. I just want to make sure it was included. And then,
Absolutely.
And can we, and maybe the next meeting as well, if we want to, and thanks for compiling those and sending those over to the board. If we want to actually publicly mention or have a discussion about those questions in particular ahead of Commander Lip coming, just so that anybody watching online or attending in person can hear some of the questions from the board, and if they have any additional questions or things from there, I think that would be a good thing for the public.
So you mean you want the public to have a chance to add questions?
I think it would be nice if we would discuss maybe the memo or the questions that we're going to be sending ahead of the conversation to Commander Lip at our next meeting, just so that we can actually verbally discuss that, so we have footage of that in case anybody has questions or additional points that they would like to add. Because right now I think they'd have to, my understanding is that they'd either have to find that online and, just kind of look through the meeting minutes to find those specific questions. And I think a more specific way for us to just send that out, I think, would be good for us to discuss.
Anything else from any other board
This
members?
is in advance of the commander getting the.
I assume you mean for the August meeting,
Right.
That's right.
because he's coming in September.
Yeah, I think the reason being is that we as board members have a number of questions, and I think part of the town hall, which a fantastic job to Dr. Ford and the entire team there, part of that was getting we got a lot of really great questions from the community, and so I just want to make sure we have more opportunities to generate questions and potential discussion among the board and among community members.
So would it suffice to have, once you all have taken a look and seeing if there's any other questions you want to add, for a recitation of the questions
That's exactly
in August? That's fine.
That's right.
Yeah, I just didn't know if of us discussing the questions prior to Commander Lip coming would be how useful that would be. Okay.
That's perfect.
Sure.
Yeah.
although the question that I asked, Chairperson, I would appreciate a conversation before the commander. I think I mentioned that to you earlier.
Do you want to talk about it now?
No,
Why not?
well, it would be helpful.
He'd like to go into executive session
Okay,
in our August meeting, so.
Got it. Got it.
All right. Anything else?
The only other point I'd make on the policy discussion, it connects to just the way in which our board operates. And not just the board operates, but within the city charter, the mayor's office, city council. We are currently at we have 3 vacancies on the review board. I think, I've been on the board since 2021. I think throughout the process, we've fluctuated with our vacancies, and I know a lot of boards throughout the city, this is a thing that happens. But I know there have been times in which I don't even know really the last time we've had a full board of 11 members. The way the process works, I know sometimes it happens where the mayor's office makes a selection of board members. They go through a training process. Sometimes the members themselves who've been selected and appointed to the board, actually something comes up where they can't serve. And so we've had a number of those instances happening. But there are other times where it does take quite a bit of time just to get the board seated. And so I think that brings up a lot of potential challenges around inefficiencies. And then also, we have a number of members, myself included, that our terms end next year, and the vast majority of the board terms end next year. And so it is paramount that I believe, have a more streamlined process to get board members onto the board. So one potential recommendation is more involvement from city council. I think city council could have an opportunity to potentially make recommendations to the mayor's office. So if capacity is a concern among, getting these applications to the mayor's office for them to review, I think it is a great opportunity for city council to play a role in actually making some recommendations for community members. They're just recommendations. At the end of the day, the mayor's office still has the power to actually make the selections themselves. But I think kind of whether that's a charter amendment that needs to change or a practice, I'm not sure the specifics there. But I think that actually might move the process along. I know other boards from other cities do that as well. I also know that the start of this board went from kind of nine members to 11 members, specifically through I'm not really sure how that process ended up working, where the city council just kind of recommended or added a couple members. So I think since that moment, there really hasn't been a whole lot of involvement. At least I haven't seen it. And I'm just speaking for myself again. I'm not speaking on behalf of the board. I want to be very clear. Speaking as an individual, I think could be more opportunity for involvement from city council. I'd love more community groups to be involved, but at the very least, city council. I don't know, Mr. Bias, in terms of what that might look like or steps that we might need to take if that's a possibility.
Yeah, so I actually got a calendar reminder yesterday about this. Pastor Nathan, Dr. Ford, and Ms. Younger here are the 4 that are up in April of next year. There's a 5th seat, but it's open currently. So worst case scenario, if all 4 of you decided not to participate anymore, that would leave the board with 4 members.
How many terms can we be reappointed?
Just two.
Indefinitely?
You can do 2 consecutively, and then I think there has to be a space, and then you could come back if you wanted to.
We've done 2.
Right.
Yeah.
Mm-hmm.
And
So then we're done.
Staggered, the 2 years for the first terms, we were on the staggered term, and then we're reappointed for a 1 3-year term. And then basically you can't do multiple terms in a row. Again, I don't really know the language there because we were 2-year and then 3-year. Some people have 3-year terms, like I think the chair does. I'm not sure what the period is between the gaps, but yes.
I'm trying to pull it up right now. If you just bear with me 1 second.
Sure.
My phone's running a little slow
It's
here.
1 year between
I got it.
serving.
Okay.
So the worst case will be the case. That is, we are done.
You're
It's
not
like-
done.
Well, I'm not done on planet Earth necessarily, but
All right. I'm agreeing with you. I have to find it, but it's 2 terms and then you have to be off. So, right. So the 4 of you would potentially be off and then you need to fill those spots. In terms of streamlining the process, recommendations of names can come from anywhere. So you don't necessarily need to change the code. If you want city council to be more involved, it would be a matter of the chair speaking to city council through the channels.
Which I will note I have done. That when IG Hendricks and I talked to City Council and gave the presentation about our report, the slowness of getting new members and seeing what assistance they could provide was a topic that I asked for some assistance with.
I think that leads to, this is an appointment from the administration side. Council sits as the approver of the recommendations from the administration. Council would not typically usurp that process and send a nominee themselves without vetting it through the administration side. I think our conversation needs to be with the chief of staff and implore on him and maybe his deputies that we have X number of vacancies and we need them filled, and that he and the city council to have a conversation about getting people on board. I just would not want to, and I agree with encouraging them to help us in terms of council, but I would imagine council's hesitancy would be they don't want to usurp administration's.
Oh, no, we've done both. Like, so if anyone has friends in either space, that would result in us getting, and just to give an example, we have reached out to the mayor's office, we've reached out to the director of public safety, we've made communications, even inquiring and following up on the applicants who were submitted. Mr. Anderson, when you applied, there were 4 applications pending. You were the only one that made it through. So kudos to you, but we also do not know what about those other applicants, and followed up.
It would be helpful to actually know what the standards were, why they didn't make it through, because I know, different ones of us did make recommendations and simply never heard back what were the issues, so that we could then say, oh, okay, next time we need to clear these hurdles.
Yeah. And we do have 1 application pending that we just received this week. And we have been calling for folks to apply, but there definitely has not been a lot of urgency with getting our vacancies filled.
Yeah, I know Ms. Ross may be in a delicate position here, but Ms. Baker Marsh and I can certainly assist if you ask us to, in terms of reaching out to the powers that be to try to get a little more traction on that. I did find members may serve more than 1 term, but may not serve more than 2 terms consecutively. So I would.
That was a policy. Is that in the charter, or is that?
It's in city code.
It's city code. Yeah.
It's statutory.
So that's a statutory.
Yeah.
Group. Okay.
The charter just establishes the creation of those bodies, then the statutory provisions,
City council
the
could
operations.
change and yeah.
Yeah, those can be changed through legislation, but I believe since.
Members serve until they're replaced.
Well, that's the next thing I was going to say. It says that members may serve more than 1. Oh, I'm sorry. It says members shall hold their seat on the board until their successors
There
are
you
chosen, qualified, and installed.
There you go.
Now that can be up for some discussion. It says shall hold, which to me means mandatory, but that's not how it was previously. It was more elective, if you will.
Well, yeah, people resigned. Like, in order to get out from under the shall hold your seat, people submitted resignation letters.
Right, exactly. And so I believe Stephanie was explaining that Dr. Ford filled a vacancy, so even though his term is up in 2026, he's only served 1 term. He filled a term, so if he wanted to stay, could stay a 2nd term, but I believe
The other 3.
Board Member Strickland, Pastor Nathan, and Ms. Younger.
Because we were on the initial
Right. We
were on the initial
wave.
Right,
of
so we're going to
terms.
kick you guys to the curb.
Yeah. Exactly.
At least for one term,
Yeah.
right?
I know.
All
some people-
joking aside, it's problematic if you can't fill those spots, and then there's currently 3 spots open. So.
Clear, if we're already, what are the number of spots that we should have?
11,
11, and what we currently have is
8,
8. And then if the 3 of us,
you'll have 5.
so then you will not have then a quorum because we're less than half of.
The way that the bylaws were written, the quorum is the majority plus 1 of the seated members.
So we would be able
3.
to function with 5.
You could function, it's not ideal.
Yeah.
Well, clearly.
Right. But, yeah.
So I,
I'll go back and review your bylaws,
And-
but I believe we purposely wrote it like
And
that.
so then, last question. So given that we're not at our maximum, your interpretation of the shall serve until place, does that mean that we need to get to 11 plus 3 in order to replace us?
I think it would be
For your particular
if who
seat.
we are so let's say we fill the 3 yeah, it's by seat. So, and this is a question that came up when one of our other board members decided not to serve a second term when their term was finished. That was a question they had. They would have been willing to stay if it meant that it made or broke quorum, but because it didn't, he turned in a resignation letter. So it is by seat. So even if we fill the 3 spots, when the 3 members whose terms end in 2026 come up, if there is no one ready and kind of in the queue to replace you, the shall means you are required to retain your seat absent you submitting a resignation
Well,
letter.
then it's exactly what I said. Then it's not. It is then 11 plus 3. In other words, the 3 new people who come on fill first the empty slots.
No.
Yes.
They,
Well,
The empty slots that are up in 2026.
no,
I mean, if you're, I agree. I mean, if you if you're trying to get the board seated, or as many members on the board as possible, and you have members that are willing to stay on, I would think it's up to the mayor's office. You'd want to fill the vacancies that were already there first. That would, I would think,
I'm
be
just
a
trying
priority.
to. I'm just trying to
It's
understand.
kind of counterintuitive because, right, you'd potentially, if someone's like, oh, I've done my 2 consecutive terms, but it says I can stay on if you can't fill my successor, and then you fill one of the other open spots, you potentially could stay on for another full 3-year term. So it's a little bit counterintuitive.
Yeah.
this also did come up before, though, because I asked the same thing. Because when we were missing a board member, and I think it was when Miss Pinkleton came on, and I was trying to figure out, well, do we have a choice of filling a vacancy that's older than the one she's stepping into, or do we have to fill the one that's only got 6 months left, and that eats into a term she could serve? And so there was language I was frustrated with about how we would fill those things, because
I'm sorry, I'm being slow, but what is the answer then?
so the in real life answer is when your term is up, you can submit a resignation letter saying you are not adhering to the shall.
Submit a
Yes.
resignation letter. That wasn't the question. The question that I have is
Right. I would
when during the next 8 months,
Yep.
as person A comes on.
I would say they
coming
are-
on to fill an empty slot, or are they
Yes.
coming on to fill?
I say they
my
are
slot?
filling an empty slot. I am not going to pre-fill a person who, they're not going to take your seat if you're still seated and we're still within your term. Now, if the 3 of you, when you become eligible to roll off the board, which is all going to happen on the same day, when we get a new board member, let's say we have 1 person in the queue, if 2 of you are willing to stay on and continue serving, then the seat that person will fill is the one who wants
Gotcha.
to go off.
Okay.
Yeah, there'll be some
And-
logistics.
Yes. Yeah.
And I think some of that is also, I mean, there's been a lot of follow-up with the city council. I appreciate you all reaching out to them, and I think that continued outreach is critically important. I do think this also could go into mind in terms of an actual review in terms of city code of the other spaces and areas where we can make this process more streamlined and efficient. To your point, Mr. Tobias, about anybody could make recommendations. I agree. I think that's, perhaps an opportunity at our town halls is to get more community groups involvement. Perhaps there's some additional stamps of approval of city councils there, because I do think that that does bring into question, and we discussed this at length when I was a member of the working group to actually establish the creation of the Civilian Review Board, which is actually the way the appointment process works. Ultimately, my argument did not win out, and it was basically the sole decision of the mayor's office with the concurrence of the council. But it doesn't have to be that way. There are other boards in which community groups or city council actually have a specified number that they get to actually make the selection. I don't think we can get there under this current code, but there are, or charter, but there are steps that should make more community involvement and more transparency in the application process. I think don't have a lot of credibility when we ask people to apply. At least, again, I'm speaking on behalf of myself and not for the board. I want to make sure that I'm clarifying that so there's no confusion here. But when I ask people to apply to be a member of the board, and they ask, like, well, who makes the selections? Well, ultimately, it's the mayor's office that makes the selection. But I don't even know whether anybody's seen their application or not. Like, I don't even know who's reviewed the process. And so I think I understand your point, Mr. Board Member Anderson, but I think the way this process has just dragged on for so long throughout this entire my entire time on the board, it's like we got to change it. Like, we've got to figure a way to change it. It's too slow, and it's I think it's personally I believe it. We've got a new process in place.
I have I have the same question. I'm just trying to figure this out. Let's say the three of us who are due to finish our terms stayed on. We used the shall. We just stayed on. Okay, there are 3 empty seats right now, correct? And you find 3 eligible candidates who pass and take it on. Don't you fill the 3 seats that have been empty first before you fill the 3 of us?
That was what I was asking, Mary.
That's
the
what I don't
answer is
understand
yes.
the answer.
But you don't have to, right?
You don't have to, but you
don't-
probably would.
Yeah.
You don't have
Okay.
You don't have to leave, but
And
fill
I-
the empty first, and then we start with Kyle and get him off, and then me, then you.
That's how it works. Okay. I did not get the answer. I appreciate the answer. Thank you.
Right, and if
And
you were to
that
get a year into this other term and they're having difficulty finding people, then if you didn't want to do it anymore, you'd have to resign.
You'd have to
That's
resign.
correct in theory.
I didn't know that they resigned.
That process
The
is
other
correct
people
in
resigned.
theory.
Okay.
It is all how it is written in legislation to council. So I want us to know that. If council decides, or if the legislation is written, that even if there are 3 vacancies, that I'm picking Robert Tobias to replace Mary Younger, whose term has expired, then it's your seat and the 3 vacancies are still there.
Gotcha.
And there's nothing we get to do to change that.
It would be incredible to see that level of focus and engagement on what's happening at the board. So I would love to see that.
Again, I stated my statement as.
I understand. I get it.
All right. Anything else for the good of the order?
Move to adjourn.
May I have a second?
Second.
All in favor? Any opposed? Any abstentions? All right, adjourned. Thank you.
Tell us when we all.